Record. All right, that looks like it's going. Share. All right. All right, everybody see the chapter 3 slides? Okay. All right. So hello, welcome to our presentation on chapter 3, Students' Rights and Restrictions. This is a really important chapter as it lays out the fundamental principles that govern the relationship between students, schools, in the educational environment. I'm Neil Bowman. I'm joined by my group members, Robert, Emily, Isabel, and Michael. Throughout this presentation, we'll be diving into key aspects of student rights, examining limitations that exist, and discussing some real-world implications of these policies. We aim to provide a clear, comprehensive overview of this topic. Okay, there we go. As you can see, the text states that school officials are are granted board powers to establish rules and regulations governing student conduct in school settings. This is a this is an important starting point because schools need a structure. These powers allow them to implement policies covering everything from dress code and attendance to academic integrity and safety protocols. The goal is to maintain an environment where learning can be achieved for everyone. However, these powers are not without limits. This is where the concept of student rights comes into play. As school officials aren't acting in isolation, their authority is balanced by constitutional protections and legal precedents. This means that while they have the power to create rules, these rules must be reasonable, fair, and cannot infringe upon student fundamental rights. This this means schools can't just create any rules they wish. Their policies and actions must be justifiable and make sense in the context of a school environment. So, what exactly makes a rule reasonable? Generally, rules are considered to be reasonable if they are necessary to maintain an orderly and peaceful school environment and advance the educational process. Which means first is the rule truly necessary to ensure the school is orderly and peacefully? Does it prevent disruption, ensure safety, or maintain a conductive learning atmosphere? Second, does it advance the educational process? Does it contribute to students' ability to learn and to the school's ability to teach effectively? For example, a rule prohibiting disruptive class behavior would clearly meet these criteria, where a rule that is arbitrarily overly restrictive or has no clear connection to the school educational mission would likely fail the test of reasonableness. This standard ensures that while schools have authority, it is exercised responsibly with a clear purpose. Since students enjoy many of the same constitutional rights as adults, courts have been very diligent in ensuring that their constitutional rights are protected. This means that rights like freedom of speech, freedom of expression, due process, and protection of unreasonable search and seizure rights are guaranteed to adults in the U.S. also extend to students. The court consistently acts as guardians of these rights, making sure that school policies and actions do not infringe upon the basic freedoms. This provides a balance that prevents schools from overstepping their authority and ensures that students are treated fairly within the educational system. In the landmark case in the 1960s, Tinker's case versus the Supreme Court, for the first time held, the Supreme Court for the first time held that students possess the same constitutional rights as adults, and that these rights do not end at the schoolhouse door. This ruling from the 1969 Supreme Court shaped how we view student rights. Before Tinker, the extent of how far students' constitutional rights were protected within the school wasn't as clear. The Supreme Court decision clearly states that students do not shed or lose their constitutional rights, in this case, particularly their First Amendment rights, simply because they walk into school. This case involved students who wore black armbands to protest the Vietnam War. The school suspended them, arguing it was disruptive. However, the Supreme Court argued, stating that symbolic speech is protected unless it is caused a substantial disruption or invades the rights of others. The phrase "do not end at the schoolhouse door" is important because it means that schools are not places where the Constitution has no sway. Although school officials have the authority to maintain order, their power is not absolute and they must respect the students' fundamental constitutional freedoms. Protests and demonstrations are considered forms of free expression. This is a direct extension of the First Amendment right to free speech as recognized by the courts. Students do not shed the rights at the schoolhouse door. And this includes their ability to express their opinions through organized activities like protests and demonstrations. However, this right, like all rights, comes with reasonable limitations. Thus, students are afforded the right to participate in these activities as long as these activities are peaceful and do not violate school rules or result in destruction of school property. They cannot be disallowed. The main thing here is the focus on peaceful conduct and adherence to school rules that protect the learning environment. Students are allowed to express themselves, but they cannot block hallways, prevent other students from participating in activities, or engage in unlawful activities like damaging school property. Courts agree students have the right to express their views, even if those views are contrary to the schools. And minor disruptions might be tolerated, but material and substantial disruptions are not. This balance makes sure that the free expression can occur without undermining the school's primary mission of educating and safety.
All right. These next slides will be discussing how, as administrators, we can work with students and student newspapers to ensure that the faculty advisors, administrators, and students are all allowed their rights of free speech while staying within the confines of school policy. If you want to go to the next slide. While it is generally open for students to voice their opinions, these opinions should be shared while embracing the rules of journalism, using sound judgment, reflecting editorial policy. Faculty advisors of school newspapers should really be focused on form, style, grammar, and appropriateness of material while allowing students the freedom to discuss and edit material as they see fit. A faculty advisor cannot be punished, demoted, or dismissed for allowing constitutionally protected material to be printed in the school newspaper. And students are allowed to express views that do not materially and substantially affect the operation of the school. You can go to the next slide. Broad censorship is not permitted and is a violation of free speech rights. Students' rights, however, are not unlimited, and they must not publish material that is libelous, vulgar, obscene, or mocks others on the basis of race, sex, color, or religion. And if the newspaper is used as part of school curriculum, school officials can regulate content that is inconsistent with the school mission. And if the newspaper is not used as part of the curriculum, the newspaper and its student editors have more latitude to report and publish as long as the content is not disruptive or defamatory. Schools take a lot less liability when school newspapers are not part of the curriculum. The main Supreme Court case that deals with this is Hazelwood School District versus Kuhlmeyer of 1983. And this is generally considered the leading case when looking at censorship of school newspapers. So this case started from a school newspaper that profiled three pregnant students and also quoted other students discussing the reasons for their parents' divorces. The principal of that school, he was concerned about the publication allowing students to discover who the article was about, um, and felt like other content in the article was inappropriate for younger readers. And finally, the principal felt like the divorced parents should have an opportunity to respond about the quotes posted in the article before they were published. However, the student editors, they claimed that the principal's actions were restraining them from their First Amendment rights. Ultimately, because the paper was part of the school's curriculum, the Supreme Court found that the principal did not violate the students' rights by ordering parts of the article to be removed from the paper. You go to the next slide. Let's see. Non-school sponsored papers. I think maybe go to the next slide. Sorry, there we go. Non-school sponsored papers. These newspapers are not school funded and are created away from school grounds. And these publications may not totally be prohibited by school officials, but there are some uh, rules that are in place with these. You can go to the next slide. So these restrictions may be imposed regarding the time and place of distribution. And since these are not prohibiting in full the distribution and publication of these papers, they're not viewed as violations of students' rights. They just can't distribute them. Like the school can say, we don't want you to distribute these at school, but it can be done outside of school. So the law doesn't see that as violating their rights because it's just a condition of when they can publish it, not just totally prohibiting them. And then the next slide. And the school assumes no responsibility to assist with the publication or distribution of such newspapers, and they're not liable for any content within. So these non-school sponsored papers, the school really is kind of removed from them, but they can still place some rules regarding the distribution and publication of these papers. And I'm done with.
All right, so my slides start off with dress and appearance in schools. So when we talk about student dress in schools, something important to remember is dressing with expression and as expression gets less protection than other forms of speech. While students do have a First Amendment right in schools, expressing yourself through clothing isn't viewed with the same level of protection as things like speaking or writing do. There is a First Amendment right, but it's all about reasonableness. Our textbook talks a lot this week about the term reasonableness a lot, but schools can regulate dress, but they have to be reasonable about it. This means rules usually need to be tied to preventing disruption to others, avoiding vulgar content, and promoting safety or illegal activities. And this has to be applied fairly to everybody. So essentially, schools have power over dress codes, but they can't just ban anything they want. There has to be a reasonable reason for everything. Next slide, please. Schools can set dress codes, but they have to have a solid reason as to why they're doing that. This defensible basis usually means preventing disruption, ensuring safety, stopping vulgar content, or promoting illegal activity, like I mentioned before. They can't just ban things that maybe school officials just don't like. They have to have a solid purpose. Next slide, please. As for slogans, slogans can be regulated if they clash with a school's core mission. So what this means is schools have a job to educate and maintain a safe, focused environment. If a slogan directly undermines that, for example, promoting violence, hate speech, or a lack of respect for learning, the school has a strong legal basis to step in at that time. It's about protecting the educational environment and the school's right of all students to learn without intimidation or distractions. Next slide, please. As for school suspensions, suspension is a totally legal and common disciplinary tool used in schools today. Legally, courts consistently uphold schools' rights to suspend students who break clear school or district rules. It's seen as a necessary tool for maintaining order and a safe learning environment. The key is that it must be applied fairly and follow due process, meaning that students usually get notice of the charges and have a chance to tell their side. As for in-school suspension, from an educator's angle, an ISS is often preferred because it keeps the student in the buildings, still allowing them to engage in some type of academics. It aims to reduce a loss in instruction while still isolating the student from their peers and delivering a consequence. It's also a way to remove a student from the classroom without removing them from education entirely. And then on the other end of that, out of school suspension is typically reserved for more severe violations, repeated offenses, or actions that pose a direct threat to the school community. And this is where the student is removed immediately from the school environment. Next slide, please. Um, for due process, it's all about fairness in our school discipline. So there are two types, and both apply to us in school. Basically, if the school is going to take something important away from us, they have to follow fair rules. So, how do schools do this? This is about following steps that the schools must take. It's the right to a fair hearing before losing something significant. Almost all school districts, 95% of them actually use out of school suspension. So this means it is a common disciplinary tool. Because some suspensions are so common, they do deprive a student of their education. So school must follow this due process. They can't just send you home without some form of fair procedure. And next slide. For a substantive due process, the key idea is so a dress code isn't about control. It has to be connected to a real school goal, like preventing disruption, ensuring safety, and maintaining respectful environment. If there is no valid reason, then the rule is not going to stick and it's not going to last. All right, that's all I got.
Right. So expulsion, as we know, is the next step up from suspension, and it is considered to be one of the most severe forms of discipline because it involves the long-term separation and potential removal from the school district. And what makes expulsion kind of tricky is that you really need to remember the 14th Amendment, which protects your right to due process. And it can also kind of be considered a rights violation due to the right to free and public education that everyone in the country has. So, to get expelled, you need to have that due process followed. And there's a whole bunch of steps that you need to go through. So, there needs to be written notice where the school informs the family why and what the reasons are for expulsion. There needs to be a fair hearing where, the student is given a chance to defend themselves. And the student is also allowed to inspect the evidence and present any evidence that they would like on their behalf, as well as the school is allowed to present evidence as well. Both the school and the students are entitled to legal counsel so they can talk to lawyers in this process of getting expelled. Both sides are allowed to call witnesses and testify on behalf of either the student or the school in favor of expulsion. And of course, there can be cross-examination. And of course, if a student does get expelled, they have the right to appeal their decision to try to get back into their original placement. So when making expulsion policies in schools, the school boards really need to define exactly what actions would result in an expulsion, and the entire community needs to be involved in making the expulsion policy so that everybody is on the same page and is on board and accepting of what an expulsion would look like. You can go to the next slide, please. So both searches and personal searches are
Sorry,
a little difficult in the school because your Fourth Amendment right provides all Americans with protection from illegal search and seizure. So schools are in the delicate position of needing to balance your Fourth Amendment protections with also the duty to keep all students safe. So what we really see here is the term reasonable suspicion. Like the first bullet point says, searches may be conducted by school personnel if reasonable suspicion is established. And what you need to keep in mind with reasonable suspicion is that it is not the same thing as it's not the same thing that police officers would need to use which is probable cause. So it's based on information that students receive from students' teachers that is considered to be reliable by school officials. Now, certain things like school property, like desks and lockers, are much easier to search because they do belong to the school, not the student. But searching a backpack or a student themselves is a little more difficult. And we kind of get this reasonable suspicion case from TLO versus New Jersey, which is a Supreme Court case for 1985, where a student was caught with cigarettes in the bathroom and a teacher searched them. Basically, that court case came out and said that you do have your Fourth Amendment rights in the school, but you do not need a warrant or probable cause to search students. So you can go to the next slide, please. So with personal searches, there needs to be a sense of urgency. Like if the school is in danger or someone is in danger, then you kind of have the right to search them right then and there. So like if you suspect a student has a bomb or a gun or something like that, then you can kind of get around having a warrant. But if a search does happen, you need to make sure that adults are present, law enforcement is present, as well as that the parent of the child is there as well. Okay, next slide. So getting law enforcement involved, basically when law enforcement officers enter the school to conduct a search, they need to have a warrant just like any other case. And if a warrant is issued, strong evidence needs to be there and probable cause need to be established. So, like I said, reasonable suspicion applies if police assist school officials with disciplinary actions. Law enforcement searches require trustworthy evidence indicating illegal activity or a crime. Parents and legal guardians need to be contacted immediately before any searches take place, and parents have the right to be present during those searches. And if parents cannot be reached or they decline to be there, a school official has to accompany the officers during the search. And attempts to contact the parents must be documented with times, numbers, and witnesses. And juvenile suspects under the age of 14 can have their Miranda rights waived without an interested adult present. And courts, once again, need to balance student rights with urgent safety concerns. Next slide. So this kind of brings us to metal detectors and things along those lines like breathalyzer tests, where the use of these kinds of intrusive methods need to be justified and seen as reasonable and necessary to meet a legitimate school objective. So like if you have a school objective to make sure that no one shows up drunk to school dance, sure, then maybe you could get away with something like a breathalyzer. But you need to make sure that it's there for a reason. And in this case, maintaining a safe and orderly school environment was considered a legitimate school objective.
All right, so corporal punishment is defined as the use of physical contact as means of discipline. While the practice may seem outdated to some, it's still a legal form of discipline in several parts of the United States. As of 2025, corporal punishment is permitted in 19 states. According to the data from the National Center for the Study of Corporal Punishment and Alternative in Schools, at least 2 million school-age children in U.S. are physically punished each year. However, when allowed, corporal punishment should only be used as a last resort. Students must be made aware ahead of time of what specific infractions could lead to corporal punishment, and if it is administered, it should never be done with excessive force or malicious intent. The courts have established 2 key standards to guide the appropriate use of corporal punishment. The first one is reasonableness, and then the second one is good faith. So the person administering it shouldn't be acting out of anger. In addition, school officials are responsible for having clear defined rules and disciplinary guidelines that give students adequate notice about behaviors that may result in corporal punishment. It is also critical that schools staff consider the student's age, size, gender, and physical condition to ensure that any punishment does not cross any lines or is too cruel or excessive. Failure to uphold these standards could result in serious consequences, including allegations of assault and battery. So while corporal punishment is still legally allowed in some places, it comes with significant legal and ethical responsibilities. Next slide. All right, classroom harassment is considered a form of sexual discrimination under federal law. This was confirmed by the U.S. Supreme Court in the case of Davis versus Monroe County Board of Education. In that ruling, the court established that school officials can be held liable if they act in a manner that is clearly unreasonable and deliberately indifferent to known instances of student-on-student harassment. Justice Sandra Day O'Connor clarified that lawsuits are only valid in cases where the harassing behavior is so severe, pervasive, and objectively offensive that it effectively denies the victims equal access to education opportunities. Importantly, school administrators are not automatically liable. Liability typically arises only when school officials are aware of the harassment and fail to take appropriate action. According to the Office of Civil Rights, school officials should be considered on notice when a student files a grievance or complaint, a student reports an issue to a teacher, or a parent, staff member, or other individuals contact a school leader regarding concerns. To prevent liability, and more importantly, to protect students, schools must take proactive steps like conducting developmental training and fostering a school climate of mutual respect where students feel safe and valued. Next. The courts have consistently held that pregnant and married students cannot be denied the right to attend school. These students are protected under the Equal Protection Clause and Due Process Clause of the 14th Amendment, meaning they are entitled to the same rights and educational opportunities as their peers. In the case of pregnant students, the generally accepted practice is that her physician will determine when it is medically appropriate for her to withdraw from school due to health and safety concerns. During this time, the school is responsible for providing appropriate home-based instruction to ensure that she does not fall behind. And then once she is cleared to come back by the doctor, she's entitled to resume attending school, and the same rights and privileges and access to the activities are essential. Ultimately, the law ensures that both pregnant and married students are treated with fairness and dignity, and that their educational experience is not unjustly interrupted and diminished. Next one. Married students, like pregnant students, are guaranteed the right to attend public schools under the law. Any school policies or practices aimed at excluding them are considered invalid and in direct violation of the 14th Amendment rights, particularly the rights to equal protection under the law. In the most jurisdictions, married students are considered emancipated minors. This means they are no longer under the legal authority of their parents or guardians and are free to make their own decisions, including whether or not to attend school. They are not subject to compulsory attendance laws, but they cannot be denied access to public education if they choose to continue their schooling. As with any other student, schools must treat married students equal and ensure they are not discriminated against based on their marital status. That's all I have.
Mute. I think we did it. It's going to kick us out here in less than a minute, it said. So
Do you want to send us a new